Okay. Look here.
Good evening, everyone. Thank you for joining us for the Colorado Law Talk. My name is Georgette Vigil. I'm the Senior Director for Alumni Engagement and Outreach at Colorado Law. During the presentation, Zoom participants can ask questions using the Q&A function at the bottom of your screen. Professor Lowenstein will respond to questions following the presentation. As a reminder, everyone is on mute. We're excited to have over 480 registrants for this evening's talk, joining us from New York to Washington, and of course, here in Colorado. Thank you for being here. It is my pleasure to introduce Jim Anaya, Dean of Colorado Law.
Hello, everybody. Welcome to this evening's Colorado Law Talk on the cases every business lawyer should know, featuring Professor Mark Lowenstein. The Colorado Law Talk series was launched in 2017 to share the groundbreaking research and knowledge of the University of Colorado Law School faculty with the broader legal community in the Denver area, and especially now that we've gone virtual, around the state and beyond. Mark Lowenstein is the Montfort Professor and Associate Dean for Curricular Affairs at Colorado Law. His research interests center on business associations, agency law, and securities law. And he also has an interest in corporate governance. He has numerous published works in these areas, and he's known for his national expertise. His extraordinary passion for and dedication to his work will be apparent to all during his presentation. All of you attending the webinar have available to you in your program additional biographical information on Professor Lowenstein. It's with pleasure that I now turn the virtual podium over to Professor Lowenstein.
Thank you, Dean Anaya. I'd also like to give some thanks to the IT crew who helped put this together, Teresa Coberly and John C. Bray. We have a terrific IT department at the law school, and we're especially appreciative in these days of remote classes and online teaching. I'd also like to thank Georgette Vigil and Yesenia Delgado, terrific members of our staff who helped put all this together. So with that, I think I can launch into the presentation. I just want to do something with these. I don't need to see my own face. I think I'll do better not seeing it. So with that, let's get started. You should have had access to the materials cases I want to cover today real quickly. I want to start with limited liability companies, looking at four important concepts and issues there. First one, using a corporate structure in an LLC. What I call unexpected fiduciary duties that we see courts increasingly applying. The oppression concept in LLCs and the fiduciary duty of good faith. I then want to move on to corporate law, look at four duties there: oversight, care, and loyalty, and approving conflicting interest transactions. That's part of the duty of loyalty. And finally, in the corporate area, I want to talk a little bit about the contractual duty of good faith, which of course covers all business entities. And finally, I want to say a word about partnership law, even though to a large extent, most new entities opt for LLCs and not partnerships or corporations. But there's an important issue there that I'd like to discuss with you tonight. So let's start out with, again, this question of using a corporate structure in an LLC. It's increasingly common, and operating agreements are set up with boards of directors and officers. And a reasonable question arises in those cases, and that is, what are the implications, if any, of using that structure in an LLC? And the subtext is, that is, will corporate law apply? And the answer is, yeah, it may apply depending on what the issue is and how it arises. The Obeid case is a nice example of that. We had an LLC that was sued by a member in a derivative type action. The managers appointed a special litigation committee and included a non-manager on that committee. And the question was, is that permissible? And the court said, no, it's not. Because you're using a special litigation committee in the context of a corporate-like structure, we're going to make the determination under corporate law. We're going to look to corporate law for guidance. And under corporate law, you can't have a board committee that includes non-board members. So in that vein, the court decided that that non-manager could not serve, or non-director really, could not serve on that committee. The court went on, the Delaware Chancery Court went on to state almost the obvious, that is, when questions of interpretation arise in a member-managed LLC, the courts should look to general partnership law. Similarly, for manager-managed LLCs, that is where we have passive members and looking to a manager to operate the entity, that's like a limited partnership, and courts will look to limited partnership law. And finally, as in this case, if you have a corporate law structure in the LLC, then the courts may look to corporate law for guidance. A more recent case, Freeman versus LLC, I post here because I think the greatest number of cases deal with indemnification rights. And the LLC statute in Delaware doesn't specifically address that. And as LLCs are contractual entities, the thought is that the operating agreement will address indemnification rights. And in this particular case, the operating agreement tracked the language of Section 145 of the Delaware Code, which sets forth corporate indemnification provisions. And they just substituted for officers and directors, members and managers. And then the question became whether the manager or member, I forget which it was, who was seeking indemnification rights, needed to be acting in a capacity on behalf of the LLC. That's the case in corporate law. Officers and directors are may be indemnified when they're acting on behalf of the entity. And the court in Freeman said the same rule ought to apply in LLCs because it appears that that was the intent of the provision that you tracked. Now, if you're worrying about the member who was seeking indemnification, the court also held that he was able to prove that he was acting in an official capacity. There was a Colorado case decided last year that takes this concept, I would say, beyond its logical extreme. Kissinger versus Fellman, which involved an intergovernmental agency that was not any kind of a business entity, certainly not a corporation because it didn't file for one, nor an LLC or any kind of a partnership. It did, though, this agency, have a board of directors and officers, and the Colorado Court of Appeals said, hey, let's treat this as a corporation. And the questions that were involved there related to dissolution and some other issues, which really should not have been treated under corporate law. There was really no reason to. So this case was brought to my attention by my good friend Herrick Lidstone, and he's written about it in the May newsletter of the CBA business law section. So you may want to take a look at that if you're interested in seeing how a Colorado court deals with a situation in which a company has officers, when any kind of a group has officers and directors. An increasingly important concept, or one that's coming up quite often in the case law, is the role of equity. And it's important in this context to bear in mind that for LLCs anyway, the general understanding, as expressed often by the Delaware and other courts, is that LLCs are contractual entities. And so what that suggests is the rights and obligations of the parties, be they managers, members, or otherwise, ought to be set forth in the operating agreement. Well, VGS is a Delaware case with an extensive chancery decision affirmed by the Supreme Court, but never officially reported. But it's important because that case shows the willingness of the Delaware courts to apply notions of fairness and equity in resolving disputes among the parties. The facts are kind of interesting. There's really two members of the LLC, a majority and a minority member. The majority member, the plaintiff, appointed two of the managers, and the minority member appointed one. The two managers, other than the majority owner, that is the one person he appointed and the minority member, those two guys got together and basically froze out the majority owner. They engineered a merger and followed the provisions of the operating agreement and the Delaware statute in doing so. They only informed the majority member after they had done their dirty deed. And he did what anybody would do under those circumstances, or at least we hope. He went to court and sued them, but the cause of action was a little difficult to articulate. After all, they argued that they were acting in the best interest of the entity, that the majority member was running it badly, and that they needed to take this action. And the court responded kind of surprisingly, well, that's just not right. We can't permit this to stand. They, being the managers, owed a duty to their co-manager, which is kind of a new duty. But the bottom line is that equity would step in and kind of resolve this dispute. I think there's a better way and a better understanding of this case, and that is that the contractual duty of good faith and fair dealing ought to apply, which is to say that under the operating agreement, while these two managers had the right to undertake the action that they took, operating in good faith, they wouldn't have done that without notifying the majority member. A more recent case from last year that got a lot of publicity was the In re Carlisle, et cetera case, where the court held that, the Chancery Court held that even though the party seeking to dissolve the LLC was neither a member nor a manager, equity would step in under these circumstances and grant standing to this party to seek a dissolution. The facts are compelling, as they are in any equity case. The parties had drafted a operating agreement, which they never kind of completed and signed off on, which would have made this particular party to the lawsuit a member with that standing. And under those circumstances, the court went ahead and said, we'll grant standing and allow them to and consider their claim for dissolution. All right, the next issue in the LLC area is one that should be a particular concern, I think, to people counseling investors in an LLC, and it's the oppression doctrine. We are all familiar with the close corporation doctrine that the reasonable expectation of minority shareholders has to be honored and protected by the majority shareholders. There are a number of cases in Colorado and beyond that express and develop this concept. And it emanates from some cases in the mid-70s in Massachusetts, which are in every corporate case book, Wilkes versus Springside Nursing and Donahue versus Rod Electrotype. In those cases, basically the court was saying that the parties entered into these closely held corporations with the understanding that this was more like a partnership arrangement and that they didn't want to form a partnership because of tax and liability reasons, but that's basically the arrangement that they had. And if the majority shareholders or a group of majority shareholders gets together and tries to freeze out a minority shareholder, contrary to the expectations that they all might have had when they formed the entity, well, equity will step in and provide relief for the minority shareholders. As I said, this is a well-accepted doctrine across corporate law, and the question arises as to whether this kind of a doctrine applies in LLC law as well, where you have several individuals coming together as members to form an LLC. Ought they have that same expectation of protection from being frozen out or otherwise disadvantaged in their relationship? Increasingly, the answer to that question in the courts is yes. And as this slide indicates, Pointer versus Castellini is a case in point, unintended. So in the Pointer case, I think the facts are particularly compelling and egregious for non-application of this principle. The plaintiff was the sole manager of the LLC, was the manager of the LLC with a contract. And his co-members thought that he wasn't doing what he should be doing and fired him. He had a pretty good case for breach of contract, if he had any case at all. But he chose to bring instead an oppression claim and say that he had an expectation of continuing on in that capacity and of possibly eventually being able to purchase their equity interests. And in a surprising opinion, at least to me, the Massachusetts High Court said, yeah, that doctrine that we developed in the mid-70s applies with equal force in this situation. And so the remedy that was given was, I thought, devastating to the other members, was well beyond anything like a breach of contract action, and brings home an important lesson, I think, for somebody counseling people forming an LLC, and that is that you have to take this doctrine into account, that it's not enough just to say in the operating agreement that majority rules, because the majority voting may have to take into account the non-contractual expectations of the minority members. That's the teaching from corporate law and applies with equal force now in LLC law. Another recent case, just to give you an example, comes out of California in 2015, the Parisi case. In that case, a member of the LLC borrowed money against his interest and gave a security interest to, we'll say, member number two. Member number two never filed the appropriate UCC doctrines, never perfected the security interest. That same member also borrowed money from member number three. Member number three knew that there was an unperfected security interest against that membership interest, and did file and did perfect his interest. So we have three members of the LLC. One of them has given a security interest in his membership interest to two of them, but only one perfected his interest. The one who perfected the interest was a manager, and the other member found out about it, sued the manager, and claimed a breach of fiduciary duty. And the court agreed and said that even though the manager was not dealing as a manager, that is, was just transacting business in his individual capacity, he still had to take into account the interests of the other member, and therefore a claim would be recognized. All right, just moving on to corporate law now. We are familiar with the doctrine of oversight in corporate law. That is, that the directors of a corporation have a fiduciary duty to make sure that they put in place a system of oversight to assure that the company is complying with applicable law. The Delaware courts first recognized this in the In re Caremark decision several years ago. And in 2006, in a case called Stone versus Ritter, the Delaware Supreme Court reaffirmed that doctrine, interestingly adopting the Chancery decision and the Caremark decision many years earlier. But regardless, the concept that emerges is a clear one. That is, the directors have a duty to make sure that they put in place a system to assure that the company is complying with all legal requirements. If they fail to do that, they clearly have they breached their duty. And what Stone versus Ritter established was that is a duty of good faith, which in turn is part of the duty of loyalty. And what that means, of course, is that it cannot be exculpated in the certificate of incorporation. All right, I wanted to, this is old learning, but I wanted to mention the Marchand case, Marchand versus Barnhill, which was decided just last year, and pretty much the same issue. This case involved the Blue Bonnet ice cream company, and their problem was a listeria outbreak at 3 of their manufacturing facilities. 3 people, unfortunately, 3 consumers died as a result of exposure to the listeria, brought a lawsuit and recovered. And then the shareholders turned around and brought a derivative action against the directors and said, excuse me, you should have been paying attention to this. We didn't have an adequate system in place to make sure that we were complying with all food safety regulations. Now, what's interesting about this is that the managers of the company, the officers, regularly reported to the board that they were in compliance with all FDA regulations, and the board accepted that at face value and did nothing further about it. The Chancery Court dismissed the complaint, saying basically that, there was no more that the directors were responsible for doing, and the Supreme Court reversed, the Delaware Supreme Court. And what they said was that the complaint did state a cause of action, and it's not enough for the directors to ask officers, is everything okay? And the officers replied, yeah, everything's cool, which has a double meaning when we're talking about a company that manufactures ice cream, when in fact, not everything was cool. And the takeaway from the case is pretty clear. That is, the board has an affirmative obligation to do more than that, to at least question the officers, to require that the officers document their conclusions that the food safety requirements of the law have been totally complied with. So it's a heavy obligation. The directors cannot defend on the basis that they made a reasonable business judgment under the circumstances. They cannot, for instance, review what the cost of a more extensive compliance system would be and to make a determination that it's not worth the cost. No, the bottom line is that they have to have in place some kind of a system to assure compliance with applicable law. The other question that, or maybe a question I should say, the Marchand case leaves open is, how far does that extend? After all, a large corporation operating in multiple jurisdictions and sometimes many lines of business obviously has lots of legal requirements to be aware of and concerned with. The Delaware decisions have not addressed that at all, but I think that's coming down the road where a company says, well, my goodness, the directors need to lean on managers and expect them to discharge that obligation, at least with respect to things that are not core to the company's business. I think that's the next area where we'll see some development here. Duty of care and business judgment rule. This is, prime ground for corporate law. What is the duty of care? What is the business judgment rule? Smith versus Van Gorkum, a blockbuster 1985 case that is in all the corporate case books, or at least most of them, is really a seminal case because it makes clear that the duty of care is not a simple negligence standard, but rather a gross negligence standard. It makes clear that there's a presumption that the directors did act with care and that the burden is on somebody challenging them to prove otherwise, or at least to make a prima facie case that they were not grossly negligent. Third, that once that showing has been made with respect to care, that is that the directors were grossly negligent, they've got to justify their decision as one that was fair to the corporation. And if, for instance, they were grossly negligent in deciding to sell an important corporate asset, they may be liable for the difference between the price that they received and the price that they would have landed upon had they exercised adequate care. And that's basically all established in the Smith versus Van Gorkum case in the context of a decision by the board to sell the company as a whole, to merge the company into the company of the acquirer. Well, as you know, there are two important consequences to this. One is that the Delaware legislature, soon to be followed by almost all of the states, allows corporations now to exculpate directors for breach of the duty of care, including breach of the, including when they act with gross negligence. That is to say, only when they act with intentional misconduct, at least in the care realm, could they be subject to this fairness test. So one thing is we now have these options for corporations to include in their articles, or in Delaware, their certificate of incorporation, a provision exculpating the directors from liability for grossly negligent conduct. This was all kind of developed by case law in Delaware and to a smaller extent elsewhere. But in the last iteration of the Model Business Corporation Act, it's now part of that act, and was enacted last year in Colorado in our Colorado Business Corporation Act. So Smith versus Van Gorkum and all of its, I guess, aspects can now be found in the CBCA, and there's less of a need to rely on case law to describe a claim against directors. Last thing on this is what kind of a duty this imposes on a lawyer drafting articles of incorporation. Do you include that exculpation provision or not? And here I think we're talking about questions of professional responsibility. If you're representing multiple parties and forming a corporation, and some are going to be active, some are going to be passive investors, that's an issue that needs to be discussed and agreed to by the parties. That is, what is the duty of care that directors of this entity will be subject to? Duty of loyalty. Lewis versus SL&E, a Fifth Circuit decision, not terribly well known, but I like to refer to this case as kind of an important duty of loyalty case. And the reason is that it represents such a common fact scenario. You have an individual forms a corporation, a business entity, a operating entity, and sells or gives shares to other members of the family, and then sets up a separate second entity in which will own the real estate that the operating company will be utilizing. What happened in Lewis was that the operating company and the real estate company did not have identical ownership. The family members who were active in the business owned shares in both, but the passive family members whom received the shares, I think, as gifts, basically just owned shares in the real estate company. Well, you can guess what happened. The real estate company and the operating company had a lease, which was not terribly favorable to the real estate company. And in a case in which we have someone not terribly appreciative of the shares that he received, he sues. And his claim is that the directors of the real estate company were conflicted because they also owned the operating company, and the lease was at too low a price. And the court said, you know what, this is the burden. The burden is going to be placed here on these conflicted directors to prove that the lease was a fair one and was at market value. And they couldn't do that. Part of the reason was they said, we're paying all we can. Otherwise we're going to be in financial difficulty. And the court said, that's not an excuse. If you can't pay a fair rental, maybe you ought to make some other kind of arrangement. So it's something to take into account when you have that kind of a situation, or really when you ever have a situation where you have passive shareholders and active shareholders, and the active shareholders are contracting in some capacity with the corporation. I'm kind of running a little short on time here. Let me just say a word about the Kahn case, controlling party transactions. When a majority shareholder enters into a transaction with the controlled corporation, and we're normally talking here about a parent subsidiary situation, the directors of the subsidiary find themselves in kind of an awkward position. That is, they're kind of beholden to their shareholder, the majority shareholder, but they're also have some kind of a duty to the minority shareholders who are interested, obviously, in this transaction as well. There's lots of law on this now. Most of it's coming out of Delaware, but some other states as well. And the challenge for the directors of the subsidiary is to try and get business judgment rule protection. That is, no scrutiny of the decision they made. The Delaware courts, as I said, through a number of decisions have said, yeah, you can do that, but here's what you have to do. The group or the directors who negotiate with the majority shareholder have to be completely independent of the majority shareholder. Can't be beholden to the majority shareholder in any way. Have to have independent counsel and independent advisors, be they investment bankers or otherwise, to allow them to negotiate from a position of strength and knowledge with the majority shareholder. Second, they have to condition approval of the transaction on the vote of a majority of the minority shareholders. And if you do all that, and you can demonstrate that you've done all that, then the court will defer to the business judgment of the directors of the subsidiary corporation. Case decided last year, the Olenek decision out of Delaware said, you've got to have all this in place before you undertake any meaningful negotiations. So the Delaware courts, as in this area of the law, demonstrate their commitment in what I call endgame transactions. That is, transactions in which the minority shareholders are going to lose their equity interest. The Delaware courts are committed to making sure that the transaction in which that occurs has all the procedural safeguards that it could have. Contractual duty of good faith is a concept that permeates the law in all areas. The general idea is that a party exercising rights under a contract has to exercise those consistent with the implied obligation of good faith. What does that mean? Well, as a general matter, it means that the way you exercise your rights has to be consistent with the understanding of the parties, at least to the extent, or at least in those instances in which the matter in question is not resolved by the contract itself. So let me put this kind of abstract notions in a context of the Nemec case, which I think is a terrific teaching tool. In Nemec, you had officers of a corporation who had retired and owned stock in the corporation. The corporation had a right to redeem that stock at book value, or a formula based on book value. The corporation, the corporate directors entered into negotiations to sell the corporation at what turned out to be quite a premium in relationship to the price that they could purchase the shares from their retired officers. In fact, the price at which they could purchase from their officers was $162 per share. And at the same time, they were negotiating with Booz Allen with the Carlyle Group to sell their division for in excess of $700 a share, more than that. Well, the directors decided to exercise their option. They cashed out the retired officers, sold the company, and the retired officers brought a lawsuit and said, you can't do that. You know, you have an obligation to interpret your right to purchase our stock consistent with this notion of good faith. And that's not good faith. The Delaware Supreme Court said, you know what, this is addressed in the agreement. There was no restriction on their ability to exercise this option. And therefore, there's no room for us to make a determination that this violates the contractual duty of good faith. It's a case that, you know, was possible to make the claim that there's good faith, but it demonstrates that the court is not going to easily exercise that kind of judicial option to expand the rights of a party. You want something, put it in the agreement itself. Last case I want to mention to you today is the St. Alphonsus Care case coming out of Idaho. Idaho doesn't get a lot of respect. Not a lot of people cite Idaho cases, but I want to give Idaho some good feelings tonight. So let me just say a word about this case. And it involves the power to dissociate from a partnership. All right, so the general rule in partnership law is that unless the partnership agreement provides otherwise, any partner can dissociate from the partnership at any time, and under modern partnership law is entitled to be paid out. Well, St. Alphonsus was a hospital, and they had a deal with their MRI Associates relating to using MRI for their MRI needs, that is for the hospital's MRI needs. They made a partnership between the MRI associates and the hospital itself. And the partnership agreement said that the hospital could dissociate from the partnership if any one of the following was true. And there was 5 conditions under which they could, pursuant to the partnership agreement, dissociate from the partnership. Well, Colorado law, which I cite here on this slide, is the same as Idaho law. It's the Uniform Partnership Act, the revised Uniform Partnership Act, and it grants the power to dissociate, as I said earlier, and provides it's wrongful only if it's in breach of an express provision in the partnership agreement. Well, the hospital withdrew from the partnership for a reason other than one of the 5 listed. And their partner said, that's a wrongful dissociation. You owe us damages. And the court said, no, it's not. It wasn't one of the 5 listed reasons, but there's nothing in the partnership agreement that said these were exclusive, and that therefore it was not violative of an express partnership agreement. So there are very few cases on this. The important thing, the important takeaway, and the reason I raised this case is that it indicates that you have to be pretty clear in your partnership agreement if folks are locked in, if people cannot disassociate. So I think that's the last slide. And if there are any questions, I'd be happy to try and answer them. Oh, you can stop applauding. It's embarrassing, please.
They are applauding, that's for sure. We're waiting for some questions to come through. Certainly one of the most popular questions this evening, Mark, is if you would share the slides in the follow-up that we send out.
Sure.
Okay.
Do you want to send that to everybody, or did you want to? Can I just send them to you? And
yes, you can send them to us, and we'll make sure they get them. There was a comment from Catherine Sutherland. She said it was interesting to see that Bluebell president was criminally indicted.
It was interesting for her, maybe, but not for him.
People are thanking you for your sense of humor and appreciate your knowledge. They are saying great talk. Let's see. Could the pointer holding implied fiduciary duty among the members in the closely held LLC be nullified or altered by an express contract between the members of the LLC? And that comes from Professor Schwartz.
Well, thank you, Professor Schwartz, for that nice softball. Absolutely. And I think that's really an important point, and that is that that the pointer case itself really is a default rule. If the LLC operating agreement doesn't directly address that question, then the judicial opinion will fill that gap. But yeah, and I think it's important whether we're dealing with a shareholders agreement in a corporation, or an operating agreement in an LLC, or really a partnership agreement in a partnership, to take into account this equitable notion of oppression of minority members, and to address it directly, and even to go so far as to say, if you want to do it in a shorthand fashion, that the oppression doctrine doesn't apply here. I wouldn't recommend that, but if you don't want to deal with the particular issues that might arise, then that's at least one way to go.
Thank you. We had some other questions come in. If Delaware seems so liberal in applying equitable principles to business relationships, why do they focus so exclusively on contract principles with the duty of good faith and fair dealing?
It's a good question. So a couple things. One is that, when you do cite an equitable case, and don't mention lots of other cases where they refuse to apply those principles, it does give kind of a skewed look at the law. So to put that in another way, the Delaware courts are quite willing to reject an equitable argument in many, many cases. So it's really the exception where they're willing, as in the cases I cited, to turn to equity. That's the first thing. The second thing is they found it necessary to rely on good faith principles, especially in LLC law, because there, and in partnerships as well, the parties can disclaim virtually all fiduciary duties. And that leaves the courts, when they're reviewing claims, say, made by minority LLC members, with very few tools to provide relief. And the one tool that they have where fiduciary duties have been disclaimed is the contractual duty of good faith and fair dealing. And so what they have been doing in a number of recent cases is to read contracts, operating agreements very carefully. And if an issue was left unresolved in the operating agreement, the Delaware courts then will return to the contractual duty of good faith. So that's the way I would answer that question.
Great. We have two more questions. Or actually, let's see. Okay, sorry, they're moving around a little bit. With all the bank, this is from John Howard, member of the Law Alumni Board. With all the bankruptcy and restructuring ongoing, could you comment on the duties of the directors towards shareholders versus a broader range of stakeholders, creditors, employees, etc.? Sorry in advance if that's beyond the scope.
Well, it's beyond the scope. Of course, I'll answer it anyway. The law is becoming increasingly clear, I think, that in the corporate context, corporate directors have to act in the best interest of the shareholders, even when the company is insolvent, or maybe in what we call the zone of insolvency. They've got to be thinking about saving the company if they can, and not necessarily worrying about the creditors. And I think maybe that's where that question was headed. Yeah, it's a tough, I think a lot of directors are going to find themselves in a very tough situation. And their actions are going to be carefully scrutinized.
Very good.
I can say about it.
Question. To what extent do you think the Caremark line of cases would apply to public entities? And that's from Catherine Sutherland.
I'm not sure what she means by public entities. I hope not governmental entities. It's not my area. I don't know.
Okay.
A political solution or a political answer to actions that our government takes. And,
She said yes, governmental agents or entities.
Yeah. No, I really can't comment on that beyond vote the scumbags out.
Gotcha. Okay. This is from Mark Waranowski. Thank you, Mark. Are you aware of a case law that would suggest that minority members could be oppressed, not by freezing them out, but by not giving them the opportunity to exit the position, even where the majority members don't exit and where the minority members didn't bargain for a put right, for sale provision or other right to exit?
Okay, so the Delaware Donahue versus Rod Electrotype addresses that in part. That was a case in which the majority members cashed out one of their own. Actually, it was the father, and his sons were then succeeding him on the board of directors. And he wanted to sell his stock. He wanted to cash out, and they agreed to buy his stock, they acting on behalf of the corporation. Well, the minority members said, me too. I'd like to sell my stock. I'm not interested in participating in the company. And they said, no, we're not interested. And the Massachusetts court said, you can't do that. If you're going to cash out yourself, you got to cash out, or at least offer to cash out the minority members as well. Now, whether that answers that question in full, I don't know. If, as I recall you're reading the question, if the majority members are not cashing out and the minority member does not have a contractual right to sell out, I'm not aware of any case or doctrine that would afford that minority member relief under those circumstances.
Very good. I have one last question. There are certainly lots of kudos for your presentation, I must say. Excellent presentation, all sorts of good news all around. So we appreciate that. One last question from Justin Conrad. Doesn't Colorado law provide that an LLC agreement, which provides for amendment of the LLC agreement by a majority vote, allow for the amendment even if it would run counter to the unwritten expectations of the minority? For example, allowing, did I already read this one? Sounds familiar. For example, allowing the removal of a minority appointed manager. I researched this a couple of years ago, and I believe this was the result. How does this square with the oppression holding you discussed, which indicated that the majority has to consider those unwritten expectations?
So, a court doesn't have to apply that doctrine if they're not persuaded that it constitutes oppression or that this isn't what the parties essentially agreed to. But I'm also aware of a case in which the operating agreement was amended to remove rights of the minority shareholder, and the court set that aside. So the Colorado court may not have gone in that direction, but there is precedent that would have supported that outcome. I see Dean Anaya is getting ready to say something. No?
Now you can keep talking.
All right. Well, if nobody asks any question, I've got
That was the last question. So I'll turn over to Dean Anaya.
Thank you, Mark, for a terrific presentation, a great overview and analysis of key aspects of business law. And thank you all for joining and for your insightful questions. By early next week, you'll receive a link to the presentation and a survey so you can share your thoughts with us. And remember that Colorado attorneys will receive a link for the CLE affidavit. The next Colorado Law Talks is one you won't want to miss. It's on June 2, 2020 with Colorado Attorney General Phil Weiser. He'll be talking on leadership in a time of crisis. If this were one of our in-person Colorado Law Talks, we'd invite you now to drinks and food with us, but unfortunately it's not. But we wish you the best and have a great evening. Thank you for joining us. Take care.
Thank you all for participating. It's been a pleasure.